Yes, I'd like to add a point to the agenda to discuss the potential recusal of a trustee.
Okay.
Is that as part of the executive session, or how does that work? That's just an item?
It'd be outside the executive session. It can happen without an agenda item. Honestly, it can happen as part of an agenda item, what will be 5.
Okay.
Then I'll remove my request, sorry.
Mayor Pro Tem Browning.
Yeah, I guess I have a question about the issue that you mentioned to Attorney Dittman before we got started, which is if the part of the agenda that was noticed out to the public as an executive session is to be changed to a public session, I guess we have to amend the agenda to do that. And I guess my question of the attorney is, how does that change our procedures when it was noticed out as an executive session and now it's going to be a public session?
So Mayor Pro Tem Browning, when I was made aware of this issue this morning, I did reach out to CML to ask about this issue. And because the employee holds the right to make it a public meeting at any point in time, it could be in the executive session and it could become a public meeting. It does not need separate noticing to be held that way because it's unknown whether it can be turned into a public meeting at any time. And so the posting of the executive session concerning this issue is sufficient for the potential of a public meeting.
Okay, and then I guess a related question is, there were a lot of memos and emails and documents that were provided to the Board of Trustees mostly by email from you or from the town staff in anticipation of an executive session. Now that we're going to do this in public session, what's the status of all those documents? Do they become part of the public record, or what do we do with those?
They can be referred to in open session as much as anyone would like, but they are at this point still attorney-client information and will not be part of the public record.
Well, I mean, some of them are communications from you. Others are memos written from the staff or emails sent between board members and staff. And so they're not all attorney communications. So I guess those that aren't attorney communications, can those be made part of the public record in a public hearing?
If someone would like to introduce them as part of the public hearing, they could be.
Okay.
It's part of the public portion of the meeting. As of right now, they're not automatically entered into the public record. They are part of the executive session record, if you will.
So if we want to refer to one of those, we would basically identify it on the record, and I'm not sure how you do that on an online meeting, but I guess they could be posted somewhere later to the public, because the public obviously hasn't had access to our emails. So I guess we would figure out a way to make those available to the public at some point if they're public records.
You can refer to them as much as you would like. If you'd like me to be part of the public record, they can be given to the clerk and posted with the minutes.
Okay, thank you.
Counselor, could you also educate us on what we spoke about, that we still have the capability to go into executive session if we feel a need for further discussion? Could you please address that issue?
The board can request to go into executive session at any time. If Administrator Simonson is to be present in that portion of the executive session, she can then ask it be put back in the public session. And if the board wishes her not to be there, then we'll have to address that if that situation arises.
Okay, so that's another option. All right. So we have.
I have a question.
Go ahead, Trustee Waugh.
Thank you. Reviewing the documents very quickly, I can't see any of them that are not open to public consideration, and I'd like us to consider to put them all in the public record. There's nothing about specific terms or performance. They're just factual communications between employees and trustees and the attorney.
Any email between me and a trustee or me and the administrator, or a memo I gave to the board should not be produced as part of the attorney-client privilege information.
Okay, well, then I'd like to submit everything that is not that to the public record.
Well, I think when we get to that portion of the meeting, we can have that discussion.
Okay. So we have a motion to amend the agenda to include audience business and a second. I don't think we voted on that yet. Is there any further discussion? Mayor Pro Tem Browning? No further discussion? I'll call for the vote, Madam Clerk.
Mayor Angelo,
Aye.
Mayor Pro Tem Browning,
Aye.
Trustee Caravas,
Aye.
Trustee Lowell,
Aye.
Trustee Miller,
Okay.
Trustee Waugh.
Aye.
And Trustee Rogan.
Aye.
The motion carries unanimously. Audience business is included on the agenda. So therefore, this is an opportunity for anybody in the audience to make a comment in regard to this issue. I don't know how many people we have, but feel free to express yourself. We serve you. We're the governing body. So does anybody in the public wish to address the Board of Trustees this evening?
Yes, I do, Laverne Johnson,
And your address, Mrs. Johnson?
306 Evans, Lyons, Colorado.
Thank you.
I'd like to say that I served on the board for 12 years, and this is an astounding thing to have happen because I was on the board when we hired Victoria, and we thought that we really got a prize. And she went through the flood. She got us through the flood and is in probably 80% of recovery. And to replace her would be a big downfall to the town because she knows so much about that. And she's really a very knowledgeable person. And I can't believe that she did enough that would cause her to be fired. If those people owe on share water, they owe. And true, she may have made a mistake, but they still owe. If they don't owe, why, that's it. I listened to the water thing the other night, and it is a very complicated issue. So I hope I sent all of you an email, but I don't know if you got it. But I certainly hope and vouch for Victoria. Thank you.
Thank you, Mrs. Laverne. Would anybody else wish to address the Board of Trustees at this time?
Yes, my name is Keith Kretich.
Continue, sir. Your address, please.
I reside at 103 Nolan Court, Lyons, Colorado.
Yes,
I
sir.
want to comment on the current agenda and the news that some members of the Board of Trustees plan on terminating Town Administrator Victoria Simonson at tonight's special meeting. It is disheartening to hear that some members of the Board of Trustees find it to be appropriate to discuss possibly terminating such a position during a time that our community cannot comment or attend the meeting in advance to voice their opinion. It is my stance that we cannot lose Victoria Simonson at this time. This time period is going to be hard on everyone in the community, and we need a leader like Victoria, who has years of experience and professionalism dealing with town affairs and emergencies. I believe other town staff, past Board of Trustee members, state, national leaders, and members of our community would agree that Victoria has been a great leader, and we would continue to need that value in our town now and to complete the work regarding a past catastrophic event and as we face challenging times and a global pandemic. All of you are either new or have only a few recent years serving on the Board of Trustees. I know firsthand that Victoria Simonson has managed a surge of events during her 10.5-year tenure. She is familiar and relies on her small town staff, and she is well aware of their strengths and weaknesses. This has caused her to be effective in her role, along with successful relationships with past Board of Trustees. She never competes with trustees for the limelight, does the small stuff well for them to trust her with the big stuff, and always makes time for trustees. Let's work at getting that confidence back together. There are many examples, but one in which Victoria and her team coordinated were the recovery efforts. They obtained much needed funding and resources, as well as negotiated contracts with state and local agencies, garnering concessions in flood recovery and rebuilds that will save the town tens of millions of dollars. If you look at historical budget numbers, you will see that the good that she has done for the town then, and the difficult decisions she will continue to negotiate. Also know firsthand that Victoria works tirelessly for our community, and very well her leadership skills in service as a public servant who has given her heart and soul to this community. Victoria has made difficult decisions. Some involve complex analysis. Some are also as simple as flipping a coin. Either way, there are many self-handicaps and at times unhappy people as a result. But it didn't and hasn't prevented her from being a strong leader, solving problems to the best of her ability in the best interest for the town. The fact that she continues to do so in an excellent example of a town administrator and for communities across Colorado in the US. I know the Board of Trustees has hard decisions to make, and I believe the mayor intends to improve our town. However, this is the wrong time to eliminate an experienced leader such as Victoria or try and eliminate any other staff positions. Is Victoria Simonson a bad manager? Not at all. Has she made mistakes? Yes, but she owns up and accepts this responsibility. Victoria has been a great manager in her role, but many times she is trying to do a manager's job while filling a leader's role. The double focus resulted in perception of something she did wrong. We all need each other, and we need a stable leader for our town who knows how to handle these situations. This is not the time to make knee-jerk decisions or terminations based on differences of opinion or personal goals. Victoria has, and I know she always will take the high road in the face of adversity. She has developed a habit of communication by discussion, whether it's by telephone, meetings, conferences, in person, during her personal walks with members of the community, day or night. She's a great communicator who puts tremendous thought and effort into everything she does. Victoria did not create the financial crisis or challenges our town now faces, and she has only tried to steer us through it. She will only do so, however, ethically and within local, state, and federal boundaries. Some may not agree with this approach. I understand our mayor and the Board of Trustees have a difficult job, as Victoria Simonson does. I also want to believe each has the best intentions for our town. Victoria has the experience and knowledge of the process to reach this goal, coupled with the ideas of new and experienced trustees alike. As elected officials, you have different needs than staff. To be effective, elected officials must be responsive to the needs of their constituents. Concerns for fairness and minority views may outweigh issues of effectiveness or efficiency. As you make a decision about Victoria Simonson, keep in mind that as elected officials, you have and will continue to face obstacles and challenges in your own choice making to do what is the right thing. You have and will yourselves act on policy, nuisances, make exceptions because they aren't always black and white or aligned with current policy or an ordinance. As you look at town goals, major projects, infrastructure improvements, while preparing for community growth, land use to finances and strategic planning. This is your responsibility with the topics of such, but also to develop a healthy relationship with the town administrator and remain ethical and respectful as an elected official. This is all reminding me of a favorite cliche. Management is doing things right. Leadership is doing the right things. In other words, the Board of Trustees are leaders who must use some management skills. and the town administrator must use some leadership skills. But understanding the differences and working within their basic framework can make the town workplace and community a whole lot more productive. Let Victoria manage the day-to-day operations, and you, as the Board of Trustees, work closely with Victoria to help ensure production is optimal. We need everyone we can get through these trying times. I know that trustees collide on issues. It's typically a rare or isolated event. That's probably because most trustees fulfill their duties with a servant's heart and are human. It's hard to imagine that this group and the town administrator cannot succeed, whom all believe in and commit to the town's mission, vision, and goals. With that, I thank you and I appreciate your time in this opportunity.
Thank you, sir. We normally don't respond to comments under audience business, but I'll respond now. I can honestly say that the Board of Trustees' intention is not to fire Administrator Simonson. And I would just like to tap that down. We're going to analyze an issue tonight. We have many options, but that is not one that I think a majority of the Board of Trustees is even considering. Would anybody else wish to address the Board of Trustees at this time? Madam Clerk, can you identify anybody?
I don't see anyone's hand up, sir, but I do have a letter that was sent to the board that was requested that I read in for the record.
Could you please read it into the record at this time?
Yes. Dear Lions Board of Trustees, aside from the town staff, I likely have more experience working with Town Administrator Victoria Simonson than anyone else in the community. During my 8 years on the board, with 4 as mayor, I had ample opportunity to observe Administrator Simonson's approach to decision-making, her ethics, as well as her overall effectiveness as a leader. We worked together during some very challenging times and can say with great confidence that Victoria makes decisions and takes actions with the best interest of the greater community as her highest priority. Please don't interpret this letter to mean that I agreed with every decision Victoria made during those 8 years. We often had healthy, productive debates that lasted late into the evening hours. In the end, I always respected her position as the head of the town to make decisions that she felt were fair and would best serve the community. That is the role of staff, and I found the town functions best when everyone understands their role and acts accordingly. Victoria is an expert town administrator, and when judgment calls need to be made, I trust her to apply her experience to seek the best possible resolution. The permit listed on the agenda as the reason for the executive session to discuss a personnel matter was a complex issue spanning decades, requiring countless hours to vet and untangle old records to trace the history of the property. Upon coming to a conclusion about a course of action, Victoria explained her decision to me, the town clerk, and the town attorney. No one disagreed with her decision. There was no nefarious intent and nothing was brushed under the rug or hidden from view. The process worked as it should have, and the staff performed their function in administering a permit based on the best available knowledge. I am concerned that some trustees are trying to influence decisions that fall under the umbrella of staff's responsibilities. Elected officials have no role in implementing policies, awarding contracts, or directing staff duties. And no elected officials should be deciding who gets a building permit and who doesn't. That is not what trustees are elected to do, and the operational decisions of town staff should never become political objectives of individual trustees. The board certainly has every right to hold the town administrator accountable for her work. It is their job to evaluate the administrator's performance and provide feedback or discipline if necessary. I have been part of this process many times and have seen that the board can be effective in managing performance objectively and constructively according to the terms of the administrator's employment contract. Certainly, if there is evidence of something dishonest or illegal, the trustees have a duty to act. That is the only reason a non-routine hearing of this sort would ever take place. And since I was involved in this particular issue at the time when the decision was made, I want to go on the record and ensure the members of this board understand that there was nothing untoward that occurred from my perspective. I sincerely hope this issue can be put to rest so everyone can focus on the pressing issues facing our town during this public health crisis. Sincerely, Connie Sullivan, former mayor.
And thank you, Madam Clerk. I'll ask once again if there's anybody in the audience who would wish to address the Board of Trustees at this time. Seeing none, we'll move on. I assume now is the time to consider Trustee Rogan's request, Counselor. Counselor?
Sorry, I was on mute when I started.
That's okay.
Since we are now at the part of the agenda where the personnel matter is to be discussed, I think it is appropriate at this time for Trustee Rogan to bring forth her issue.
Trustee Rogan?
Thank you. I have a short statement that I would like to read. It is, first of all, with absolutely no pleasure whatsoever that I bring this topic up. I would like to discuss whether Trustee Waugh should be recused from this discussion. I spoke directly with him about this morning. I was told by two people that Trustee Waugh said he ran for office with the express purpose of having Town Administrator Simonson removed, and that he ran for office to settle a vendetta he has against town staff for their past actions. I feel ethically obligated to bring this information to the entire board, to staff, and to the public. I believe that Trustee Waugh may have a personal conflict of interest based on bias and predisposition with regard to his desire to terminate Town Administrator Simonson, and that this conflict of interest cannot be cured via a disclosure. Thus, I am asking the board to consider whether Trustee Waugh can participate in this discussion pursuant to Rule 7 of the legislative policy.
Is that in the form of a motion, Trustee Rogan?
Yes, I think the board should vote.
Do we have a second to Trustee Rogan's request? Mayor Pro Tem Browning.
I will second so that it can be discussed. That does not necessarily signal that I will vote for it, but
I
get it on the
understand.
discussion table, I will second.
I understand that. Counselor, do we vote on it before discussion? Excuse me for not knowing.
This is a unique situation because it is under legislative policy, but I think if there's any discussion at this point, I think now is the time to do it, and then a vote on the final resolution of the matter whether Trustee Waugh must abstain from any vote on the actual action that may result from this matter.
Okay, I agree. So we'll have discussion at this time. Let me call on Trustee Waugh to state his position on the issue and whether he feels that he can make an impartial decision in regard to this.
Thank you, Mayor. And Trustee Rogan, I appreciate you bringing this to everyone's attention. I would like to say that the motion is not correct because I cannot be forced to be recused myself. It can only be that I be abstained by a vote of the board, as this has happened to me before. So I just want to state that this is for an abstention, not for a recusal.
That's correct.
I did want to comment to the accusations. I am running to get Victoria fired, or I am running to get Victoria removed from office. Definitely sounds like something that I would have said during the campaign and something that I would admit to. I'm trying to serve or solve a personal vendetta. I don't agree with that. I'm trying to, as my ethics and my board commitment and my oath, I am working for the betterment of the town of Lyons and for all of the citizens of Lyons. So I apologize perhaps for the irresponsible wording during my campaign, but I am entitled to set my platform and my opinions and feel that many members of staff are not doing the jobs for which they are hired. And I personally have seen not only myself, but many other citizens in town being given the undue runaround and other complications due to some type of lack of performance or the performance issues that we're going to discuss as they relate to the personnel issues of Victoria Simonson, our town administrator. I also feel that a recovery town administrator is not the same as a growth and future town administrator. And according to all of the research that I can find, a typical town administrator or city manager has a tenure of 4 to 6 years. Victoria has been here, and while she's done an amazing job at flood recovery and advocating for many, but not all of our citizens, and is proactive on many issues, I feel that I have the First Amendment rights to say what my platform is and to stand by it. And I can be objective. And I want to say, I know it's not even time to say it yet, I believe that Victoria did the right thing by the owners of property at 812 Mountain View. And I'm glad that it was resolved in the way that it was resolved. However, there's a lot of inconsistencies that we'll be discussing during the course of the discussion tonight. And I would appreciate all of the members of the board and the public realizing that when you own businesses in town and you own commercial real estate and you're a landlord and you do many things in this town, you have involvement with many other people in the town, especially when they're members of participating in the community. This is the third time since I've been a member of the board that I've either been asked to recuse myself or abstain from something because of a personal interest. I have no personal interest. I have no actions in front of the town administrator or the town staff as an individual right now. And abstaining or recusing myself from this vote is unnecessary. And I would appreciate that you take my oath that I made in front of all of you to my word, that I can be objective and I'm serving the best interests of the town, not my personal self-interest. Thank you.
Thank you, sir. Any other comments? Mayor Pro Tem Browning.
Yes, I think this is a legitimate issue. However, I want to emphasize that what is before this board tonight, or this afternoon, it will be tonight before we're through, is fairly narrow in scope. It is a question of what action should be taken from a personnel perspective based on actions that the town administrator and others were involved in. That's a fairly limited issue. What's before us tonight does not involve town policy about water shares or the issuance or revocation of a permit for this particular property. That was handled at another meeting. So it's a very narrow issue tonight, which is what action, if any, should be taken with respect to the matters that we'll get into in terms of the details of what happened. Because that issue is narrow, I don't see that there is a conflict of interest that would compel recusal or abstention. I don't fault Trustee Rogan at all for bringing this to the board's attention. It does warrant consideration, but I don't believe that the circumstances exist under the rule of procedure that applies to this that would require mandatory recusal or abstention for this particular issue.
Any further comments?
Oh, I'm sorry. I would like to make one more comment, Mayor, if I might.
You might.
I want to make it clear that I do not mean to impugn Trustee Wah's character as a person. I want to make it clear that the reason I bring this to the board is I feel ethically obligated to, as people in the town have brought this to me. So it's a matter of shining light on a subject for the purpose of transparency.
And I appreciate that comment, Trustee Rogan. I'll make my comment now. I think that election comments, running for office comments, and performance once one is elected are two different matters. Once one is elected, the capability of personal vendettas, agendas, promises, all go out the window because we don't have I'll just say it, we don't have the right, once we're elected, to perform in a manner that behooves us personally. That is absolutely an ethical violation. I will take Trustee Wah's word that he can indeed be objective in regard to this issue, and that's my statement. Does anybody else wish to add anything to the discussion? We have a motion and a second. We've had discussion. Now we'll vote on it. Let's say an aye vote is to approve, and oh, excuse me, Trustee Miller, go ahead.
It's okay. Just have a question for clarification. We're voting to ask him to abstain, or we're voting to not have him abstain? I guess the wording is.
It's a good question. Because the motion was in the form of should Trustee Wah
Right.
abstain from any action resulting from this matter, a vote yes would be for him to abstain, a vote no for him to be not to abstain.
Okay. Everybody understand?
And I guess I will abstain, right? I don't get a vote.
You can vote if you so choose. The legislative policy doesn't say whether or not the person in subject has to abstain. So you can vote on this if you'd so like.
Okay, just to be clear, a vote yes is to force Trustee Wah to abstain. A vote no is to allow him to participate in the discussion. I'll call for the vote, Madam Clerk.
Mayor Angelo,
No.
Mayor Pro Tem Browning,
No?
Trustee Caravas,
No.
Trustee Lowell,
No.
Trustee Miller,
No.
Trustee Wah,
Abstain.
Trustee Rogan.
No.
Trustee Wah will be allowed to participate in the discussion. Thank you very much. I think that was worthy of a discussion. Madam Clerk, could you please read item 4 into the record?
Yes, this was an executive session pursuant to Colorado Revised Statute, Section 24-6-402, 4F, for the purpose of discussion of personnel issues concerning Town Administrator Victoria Simonson and the issuance of a building permit for 812 Mountain View, Lyons, Colorado. Town Administrator Simonson was previously informed of the meeting, and she does wish to have it an open discussion.
Thank you. Counselor, could we have a short statement, please?
Thank you, Mayor. So I think the subject of this is pretty self-explanatory. This is personnel matters specifically relating to Victoria Simonson and specifically relating to 812 Mountain View and the issuance of a building permit. This is not for discussion on issues that lie outside of that scope. Also, it is the town administrator's desire to have this an open session, so it will be an open session pursuant to her right in the open meetings laws. And if there's any point the board would like to go into executive session, we can readdress the issue, whether at that time the town administrator would like it to be open or closed. But at this time, it is an open session pursuant to her desire. And that's really the only statement I have to make on this. I provided materials to the board. I think several people would like to give their statement on this, but I'm primarily here to answer questions.
Thank you, sir. Just as a format, we'll proceed as we always proceed. I will call on each member of the Board of Trustees to make their statement, and then we'll enter into a question period. And and we'll proceed. I always do start with Mayor Pro Tem Browning.
Angela, I guess I have a question. I mean, I think that what I envisioned was that the staff normally does a presentation first, and then the board can ask questions of the staff. And then at the end, when a motion's on the table, we make a statement. So, I mean, I have a fairly large number of questions of the various staff members here. So I guess my opening statement, if I have to make one, is that I would like to hear the staff positions first if they wish to say anything. If they don't, then we can just start asking questions.
Okay, I think that it's the position of staff to not make a statement, but that they would be willing, obviously, to answer questions. Madam Administrator, do I have my understanding correct?
Well, staff did not request the executive session, so I'd like to request that the person that requested that there's a problem explain the situation to the public. I submitted our statement, Dolores submitted her statement. We don't, you're the one that's requesting a personnel decision on an issue. So we would prefer that, I believe it's Mayor Pro Tem Browning is the one who brought this to your attention, Mayor Angelo. So we'd prefer he give an overview of the situation.
You can proceed, Mayor Pro Tem Browning, in any manner you wish to, whether it be a statement, whether it be questions. Proceed, sir.
Okay. To be clear, I did not request an executive session. I thought it likely that an executive session would be held because until literally we started this meeting, none of us had been informed that the town administrator wanted this in public session. I didn't receive any emails about that. It is her choice under the statute. It's always been her choice. And because it was noticed by the town clerk as an executive session, I think I, along with the other trustees, assumed that's what we would be having. I think the public would assume that too, but that is her option. And if she's opted for an open session, that's fine. And if none of the staff wishes to make any presentations to the board, which is the usual order of procedure, then I guess we can proceed to board questions. And like I say, I do have a number. Since this is a public session, I would think it's appropriate to inform the public that Town Administrator Simonson and Town Clerk Vasquez have submitted by email memos to the town board reflecting their positions on this matter. And those are not actually in this record. I think they should be put into this record. How you do that in an electronic meeting, I'm not sure. I would ask the town clerk to figure out a way to do that and make those available to the public as best that can be done. A memo, I believe, was also prepared by the property owner at 812 Mountain View, Mr. David Wickham. And I think that belongs in the public record also. The Board of Trustees has also had the opportunity to review numerous emails regarding some documents regarding this matter. Other than those which constitute attorney-client communications, which, as Attorney Dittman has already indicated, are privileged and that privilege should not be waived. The non-privileged emails, those between staff members, between the board and staff other than the town attorney, I think those should go into the public record as well, because I don't think it's possible for the public to understand the background of this matter without all those emails and documents and memos at some point being available to the public. The normal procedure would have been, had we all known that this was going to be an open session, a number of those things would have likely appeared in a packet that the public could, that both the board and the public could review in advance. That didn't happen here because this got noticed out as an executive session, and executive session materials are not part of the public packet. So we're in kind of an odd situation here that something was noticed as an executive session. It's now being held as a public meeting, but the public didn't get its normal advance notice of the documents relevant to the public meeting. I will state for the record that there was a prior special meeting of the board that was held on July 22nd. There were materials posted in the packet available to the public as part of the record of that public meeting. And that meeting concerned whether to revoke the building permit that was issued for 812 Mountain View, which is something the Board of Trustees has the authority to do. We had a meeting on that. We discussed it. Vote was taken not to revoke the permit. So I would, for any member of the public wishing to look at background documents and materials on this, to a limited extent, there are some available on the town website under the July 22nd meeting packet. So I guess that's kind of where we stand on the record. And I do have a number of questions of various members of the town staff that I'm ready to proceed on, but I guess I would first ask, does any other member of the Board of Trustees want to make reference to things that should be in the record and stuff? Because I think we all ought to be clear what the public's going to know about this matter and what it's not going to know before we start down the questioning round. So I'll just see if there are any other trustees who wish to comment about what belongs in the record of this public meeting.
Trustee Watt.
Yes, I'd just like to state that at that executive session, the board voted to have me abstain from the issue. I believe it was based on erroneous information regarding my vacant lot. I have been paying and connected to the water system for over 30 years at this property, and it will not require or dedicate a share. But I was asked to recuse myself because it was in question. And my fellow trustees decided that to make sure that everything looked above board, that I should abstain. And I did abstain. I actually recused myself and left the meeting, but I believe that vote and the information that was presented at that meeting was incorrect. And the reason that it was stated that I should abstain was not correct.
Any other comments in regard to what materials should be available to the public by any of the board? I think that every single item that isn't covered by attorney-client privilege should be made available to the public. I mean, if we're going to define transparency, then that's exactly what we should do. Trustee Caravas, I see that your mute is off. Do you have a comment, sir?
I was just going to state basically what you just stated, that everything that can be on there should be on there, on the record, that is.
Thank you, sir. Anybody else? Proceed, Mayor Pro Tem.
Okay, I'll start this by giving a little background and context, and then I have, like I say, quite a few questions. At a meeting in a Board of Trustees public meeting in June, I believe it was the second meeting in June, during the finance presentation that Finance Director Johnson made to the board, she made note that the town had received some water tap fees and sewer connection fees, I believe it was, for the property at 812 Mountain View. And the amount given for the water tap fee was like $14,600 and some odd dollars. It was kind of notable for a couple of respects. One, that was the first set of tap fees that the town had received in quite some time, first one of the year actually, and we do budget for those. And so that it was brought to the board's attention that tap fees for water and sewer had been paid to the, had been received by the town. After that meeting, roughly a week later, I emailed Finance Director Johnson and Town Administrator Simonson with a couple of questions about the tap fees. Number one, the amount of the water tap fee didn't match the $17,500 in the town code, and I wanted to see what the difference was. So Finance Director Johnson quickly, and as she usually does, competently explained what the difference was. The difference was that some amount of the tap fee goes to Longmont. I also asked her, did we get an electric connection fee? And she confirmed that we did. And as the third question in that email to her and Town Administrator Simonson, I asked, and did a water share get put up for 812 Mountain View? The finance director responded that she didn't handle water shares and I would need to ask other members of town staff about the water share. So I immediately sent a second email, again addressed to Town Administrator Simonson, but also to the Development Director, Paul Glasgow, and also to Town Clerk Vasquez to ask, did we get a water share for 812 Mountain View? That was sent, I believe, on a Monday or Tuesday. I waited 3 days, hadn't had a response from anybody. So I sent a third email to the same people and said, I haven't had a response to my inquiries about a water share at 812 Mountain View. Finally, in response to that email, I got an email from Town Clerk Vasquez, who explained to me that essentially the water share had been waived for that property. And she attached a couple of documents to her email. One was a 2017, I believe it was, opinion letter relating to another property in another subdivision about water shares. And the second was a staff memo dated May 1st, 2020 that summarized why a water share had been waived for 812 Mountain View and kind of why, and gave a little background. At that point, I had heard nothing from Town Administrator Simonson, even though I had sent 3 different emails. So I responded to Town Clerk Vasquez with some questions and comments about that, and expressing concern how a water share had been waived when it had never been brought to the attention of the board, and that the Lyons Municipal Code provides that only the Board of Trustees in its sole discretion can waive a water share requirement. Only after that email did I finally hear back from Town Administrator Simonson after my 4th email. Very short email on her part, that this will all be in the record, I presume, that basically this was a complicated issue and she'd be glad to try to sit down and she would gather the emails and documents relating to the decision and would be amenable to discussing that with me. So that's how this issue came to light. It was basically took 4 emails to town staff to get this rolling, or 3 before Town Clerk Vasquez responded. And I guess with that background, I do have some questions of, I'll actually like to start with Town Clerk Vasquez. And again, there will be some memos in the file and some emails in the file that will kind of reflect some background on this matter. Ms. Vasquez, in your responses to my emails and in your memo, you indicated that after the Board of Trustees in March of 2019 had changed the town code with respect to water share requirements, you had a conversation with Attorney Dittman about that change, which we all tend to call Ordinance 1055. It's now part of the municipal code, but that was the ordinance number. Could you kind of summarize what the discussion was with Town Attorney Dittman about the effect of Ordinance 1055?
Would you like me to read my statement in for the record? Everything that I remembered from the very beginning of this is in that statement. I could certainly be happy to read that in for you.
I mean, there are emails about this too, but I don't know. I guess we could do that. I mean, the statement will be in the record. I really just was kind of hoping for a brief summary of what the conversation was, but if you want to answer that by reading your statement, I guess that'd be fine.
Sure. This was addressed to the mayor and to the Board of Trustees. This was in the packet that was sent to them for the executive session. And this is everything that I can recollect on this property and what happened. And it starts off on March 5th, 2020, Victoria, Dave Wickham, and I met in the boardroom to once again discuss the water share dedication requirement for Mr. Wickham's lot at 812 Mountain View Drive. This conversation has been taking place now for several years. In 2018, a building permit for 145 Kelling Drive was applied for, and this opened up a big discussion on water share dedication requirements. Ms. Sarah Moyle and her contractor, Mike Donahoe, argued adamantly that she should not be required to dedicate a water share, as not one other person in that subdivision had been required to. Mr. Wickham owned 2 lots on Mountain View Drive and was in the process of selling one. I can't recall if Mike Donahoe notified him of what was being discussed, but he was in on the talks. Staff spent many man-hours researching old files, minutes, and records. Staff was unable to find any conclusive documentation that any other homeowners had dedicated shares or that the original developers in the 1970s had either. Back then, this was common practice. No one was required to. The homeowner at 145 Kelling, Sarah Moyle, contacted Mayor Sullivan and staff met and discussed all the options. Legal counsel at the time also weighed in and drafted a memo which concluded that 145 Kelling did not have to dedicate a water share. Mr. Wickham followed up, and I recall a meeting in Victoria's office with Deb Anthony, Dave Wickham, Victoria Simonson, and Mayor Sullivan, and I couldn't remember, it may have been on the phone, the mayor. I went in for a short while and pulled files and was brought up to speed. I do remember those 2 lots being discussed at length. Those 2 lots were in the exact same boat as the Kelling lot. No clear documentation on water shares for original subdivision agreements, and not one other homeowner had dedicated shares. Mayor Sullivan again weighed in with staff and determined that these lots should be treated like the Kelling lot, and this would end the debate. I do recall Deb calling Mr. Wickham, and he was told that he did not have to dedicate a share. I know Mr. Wickham asked repeatedly if he could get a letter stating this fact. To my knowledge, that letter was never drafted, only the letter for 145 Kelling Drive. Mr. Wickham, Victoria, and I met on March 5th, 2020, as Mr. Wickham was ready to now build on 812 Mountain View, and the water share dedication issue came up again. The board had passed ordinance 1055, and we told him he would need to dedicate a share. To say he was upset is an understatement. He was livid and reiterated to us how over the years, several staff members from Jackie Watson, Clerk Anthony, and Mayor Sullivan herself had confirmed that this lot had met all water share requirements. March 13th, the world fell apart with COVID, and this was not even a thought for me. We fast forward to the end of April. Mr. Wickham is wanting to pick up his building permit. On April 30th, 2020, Linda Lee, our permit tech, asked again what was decided with Mr. Wickham. I went into Victoria's office and we called Attorney Dittman. We went back and forth on old records, legal restrictions on SIAs, land use code, and the inability to impose different obligations within the same subdivision. Also discussed was the fact that town staff had repeatedly confirmed with Mr. Wickham that he had met requirements. We knew that he had been told that. Those 3 lots, the 1 on Kelling and 2 on Mountain View, had been counted in as part of the old original town plat and were covered in staff's opinion. Mr. Wickham paid all his permit fees and picked up his permit. The town upheld its word. I feel confident that the right decision was made, and I stand firmly by Administrator Simonson, the Town of Lyons, and any contribution I have made to this decision.
Thank you. Let me ask you about that March 5th, 2020 meeting with Mr. Wickham. Didn't you express the opinion as town clerk in that meeting that a water share was required?
Yes, that's what the letter stated.
Okay. And what did you base that opinion on? Why did you think he was required to put up a water share if he had been told earlier that he didn't have to?
Also in the letter, it stated ordinance 1055.
So the town had passed a new ordinance. And in between the time that the town board passed a new ordinance in March of 2019 and then March of 2020, when you and Ms. Simonson met with Mr. Wickham, did you have a discussion during that interim period with the town attorney about the effect of ordinance 1055?
In between the meeting?
No, in between March of 2019, when ordinance 1055 was passed, and March of 2020 and 20, when this meeting with Mr. Wickham occurred. There's about a year in between there.
No, not that I recall.
Well, Attorney Dittman has told us in an email that he had a discussion with you after the meeting, after the ordinance was passed, excuse me.
After the March 5th meeting.
No, after the town board of trustees passed a new ordinance in March of 2019, ordinance 1055. And then Attorney Dittman has informed the board that he had a discussion with you between that. Did that discussion take place?
I don't know what discussion. Attorney Dittman has his hand up. He may recall it.
Can I provide some context? So,
Go ahead, sir.
Sure.
So I believe that the discussion that you're referring to was a discussion I had with Deb Anthony, and also I think Dolores was present. That was hard to recall. It happened right after Ordinance 1055 was passed, and kind of the history of that whole ordinance, which was complicated. And the discussion was basically from Deb asking, so will this ordinance now apply to all new lots? And my answer at that time was yes. The intention of the ordinance was to apply to all these unannexed and are previously annexed and subdivided lots. And that was done immediately after the passage of the ordinance. It was a phone conversation. It was not an in-person conversation. It was short, like many of my conversations with town staff, usually when I'm running from one place to the next. But I do recall that conversation happening. And I believe Dolores was on speakerphone, as she often was when I called Deb. But beyond that, I can't really speak to the specifics. It's one of, tens of calls I have a week with town staff.
Okay.
Over a year ago.
Thank you. So, Ms. Vasquez, as of March 5th, 2020, when you and Victoria and Town Administrator Simonson met with Mr. Wickham, you expressed the opinion then that he should have to put up a water share, correct?
Based on the passage of that ordinance, yes.
Okay. And as you said, Mr. Wickham disagreed. And
Right.
what was Town Administrator Simonson's position at that meeting?
Well, everyone was trying to follow the rule and agree that, this new ordinance was passed, and that's what he was told in the meeting. They passed a new ordinance and it's requiring a water share for everything, for any new service connection. And that's when, he stated, I have been told repeatedly, reassured by the town, and the meeting went on, but that was the crux of it.
And what position did Administrator Simonson say about whether a water share had to be put up or not?
The same.
That it did or did not have to be put up?
It did.
She took the position in that meeting that it had to be put up?
Yes.
That's inconsistent with what the board has been informed again.
That's exactly what's in my statement, sir.
Okay, but
And it's in what's in my statement is that I told him he had to put one up. That was my initial response to him until we consulted again with Attorney Dittman, in which he does not recall this conversation. And he agreed that no, we must keep our prior commitments to these lots.
okay. Ms. Vasquez, what you sent me on the first, when you responded to my email of inquiry here, was says staff memo, and it's dated May 1st, 2020. It has 3 signatures, but from what we can tell, it was never signed. It's had a signature for Ms. Simonson, for you, and for David Wickham. Did you prepare that memo?
Yes, that was my notes from what I recall from the meeting and from the phone conversation.
So this was your recollection from the meeting on March the 5th?
And after the phone call with Brandon, so we could remember what was going, to stick it in the file and have record of it.
Okay, so this was written after the subsequent discussion with Brandon. It wasn't written after the May 5th, March 5th meeting, right?
No, not after the March meeting, because then COVID hit and he didn't come back in here. The building was shut down. We didn't see anybody. And then at the end of April, beginning of May, he wanted to come in and pick up a building permit. And that after that discussion, the phone discussion, I tried to put everything in writing so we would have it for our records.
Okay, so it's your position that the final decision on waiving the water share was made after a phone discussion in late April with the town attorney.
Right, we all were in the office. Well, Brandon was on the phone and me and Victoria called him because we were like, what do we do now?
That's the one that you said that there are a lot of things discussed on it of past history and agreements with other properties and kind of stuff.
Right.
How long did that phone conversation take place?
I don't know.
I mean, how long did it take?
I don't know.
Okay. No recollection of it.
No, I wasn't timing the phone call.
Okay. Because do you realize that that we've been advised the town attorney has no recollection of that conversation at all?
Absolutely.
Yeah, I've heard him say that.
Okay. So the permit was issued on May the 1st, correct?
Yes, I believe so.
Okay. And who actually issues the permits?
Linda Lee will come up, will handle all the building permit stuff when they write the check and have all their insurance and stuff.
And
Yes,
does she actually sign them?
I believe so. She's the building permit
Right.
technician. Yeah. I think, didn't she send you a copy of it?
Could be. There was a lot of documents. But Town Administrator Simonson has told me that she doesn't sign building permits, that somebody else doesn't.
The town administrator has never signed them.
Right. So Ms.
That's
Lee, the permits. So who finally gave the direction to the permits clerk to sign a building permit?
It was either me or Victoria that came out and said, you know, because she had emailed and asked. And it was either me or Victoria that came out and said that it was going to be okay to issue it.
Okay. And as far as you know, she issued it on May the 1st.
Yes, he paid all the fees and picked up his permit.
Okay. Among the fees he paid on May the 1st was one of them a water tap fee?
You said there was, it was reported there.
I'm just asking about the timing of it. Was it approximately May the 1st?
I have no idea. I don't have the permit in front of me.
Okay. Do you keep the water tap permit records, the water tap fee records, I should say?
All of those goes with payment and that are attached to the permit itself and stuck in the address file.
Okay, but do you keep track of the water taps that are issued?
Yes.
Okay. Had a water tap been issued for 812 Mountain View before 2020, let's say?
No.
There wasn't an old tap. There wasn't an old tap for that property. Is that right?
No, sir.
Okay. Rather than, I guess now I have some questions for Town Administrator Simonson. I would ask if any other trustees have questions of Clerk Vasquez before I talk to.
Are there any other questions for
Simonson?
Town Clerk Vasquez, Trustee Wah?
First of all, I'd like to thank Clerk Vasquez for taking minutes from the March 5th meeting. Thank you very much for that. That's unusual that we have such good documentation. I'm curious why there was a signature block at the bottom.
Well, we were going to have someone sign it and then the building wasn't open, just so people would, because we've had this come up so many times, just to know that staff knew that this was being done, the homeowner knew that this was being done, and we could stick it in the address file. But the building wasn't open when he came for the permit, and it never got sent out to anybody or signed.
Was there also a letter discussed at the 2017 meeting that Mayor Sullivan attended? That there was going to be I think we said there was going to be a
Dave
legal.
Wickham was always under the impression that he was going to get the same kind of letter that was issued for the Kelling property. And he never got that letter, to my understanding. And
Was it your understanding at that meeting that that letter or that opinion was offered as something that might be forthcoming?
that the letter would be coming?
Yeah.
Yes, Dave did think he was supposed to receive a letter because, like I said, he had 2 lots up there, and he was, you know, he was in the same boat as the Kelling property. So he thought he wanted a letter as well. But at that time, so the old letter for Kelling came from the old attorneys.
Okay.
We were in transition to the new firm, and I don't know if it just wasn't communicated. I don't know why it didn't get drafted, because I know at length those 3 lots were discussed.
Okay. I'm just trying to determine, did he want a letter? It sounds
he wanted
like
a letter, and he thought
like
he was going to get one.
it sounds like he was expecting a letter.
Right.
And if he was expecting a letter, then that expectation was set. And I'm wondering if that expectation was set at the 2017 meeting. That he would
I don't know. Like I said, I wasn't.
I don't know. I'll ask Victoria this, or Town Administrator Simonson, the same question. I'm trying to show a pattern of behavior with regard to letters. So I'm just trying to get to the bottom of, was he told he would get a letter that never was forthcoming?
And that I don't know, because I know he had talked with Deb and Victoria, and like I say, we were transitioning from the old legal firm to the new firm. I don't know what happened, White, but he kept saying I was supposed to get a letter, and no letter came. I don't know where it came from.
Okay, thank you.
Any further questions for Town Clerk Vasquez? Trustee Lowell.
Thanks, Mayor. Town Clerk Vasquez, I have just one question. When you describe Mr. Wickham's anger, I guess, at that March 5th meeting, do you recall at any point that he threatened the town with any lawsuit?
No, I don't recall him threatening lawsuit, but he was pretty livid, because like I said, this has been going on since like 2017 or 18, and he's been told, but I think in anger and maybe more disappointment, he was more like, we're here again. I've been told, so it was kind of a mixture of both, but he didn't ever threaten anyone.
Okay, thank you.
Yes, sir.
Trustee Miller.
Yeah, I just have a question about the second lot that Wickham owned. That got sold off, right, to somebody else? Have they ever come to build on it or?
Oh yeah, they built on it and live in it, and they also did not dedicate a share.
Okay.
It was these 3 lots, yes.
Any further questions for Town Clerk Vasquez? Mayor Pro Tem Browning, do you have questions for Administrator Simonson?
Yes. Ms. Simonson, your memo to the board dated August 14th begins, as you know, the issue of water rights, water shares, and water taps are complex topics. The situation at 812 Mountain View was yet another example of not having clear documentation of what was agreed to by previous boards, yet trying to honor what individuals say that they were told by town officials. I'd like to read to you the heart of Ordinance 1055, which is now Section 13.3-90 of the Lyons Municipal Code. And it says, all new connections or taps shall meet the water share dedication requirements. What do you find complex about that sentence?
I don't necessarily find that sentence to be complex.
Well,
I'm saying
I'm sorry, go ahead.
I'm saying that in regard to this situation, this is just yet another example where water rights, water shares, water taps is complicated and has changed over the years. Ordinance 1055, I understand what it states.
Okay. At the January 22nd, 2019 meeting where the board was considering ordinance 1055, Attorney Dittman made this statement as reflected in the minutes. Now everyone has to dedicate a CBT share. Do you find anything complex about that?
No.
So we've got a code provision that says all new connections or taps shall meet the water share requirements. And we've got the attorney's guidance that now everyone has to dedicate a CBT share. So did Mr. Wickham's lot have a connection in 2020, before 2020?
Not that I'm aware of.
I'm sorry, I couldn't hear.
Not that I'm aware of.
Did it have a tap before 2020?
Not that I'm aware of.
So it required both a new connection and a new tap when he applied for a building permit, correct?
Yeah. And so when he came in and asked for one, I told him you will need to dedicate a water share.
Okay. But you ultimately waived that share.
I did change my mind on that decision after consulting with the attorney.
So what you're telling us here is that really the decision to waive the share was the town attorney's decision.
No, I will take responsibility for me and my department head's actions. I made that decision based on the fact that we determined that this property already had a water share dedicated to it and didn't need another one.
How did this property have a water share dedicated to it?
Because all properties that were brought onto the Longmont water system in 2003 that were platted were considered to already have a water share.
Okay. So that was true for every lot in Mountain View, correct?
Unless something has been platted since that time.
I don't think there's any evidence of that. We had the plat of Mountain View introduced, I believe, at the July 22nd hearing. The Turner and Reed subdivision, First Avenue, Overlook Drive, that got platted, I believe, in 1924 when I looked at the files last week. So, and it was part of the original town limits too, right?
I would need to look at the plat.
Okay. The Kelling subdivision that was the subject of the 2017 attorney letter, that was in the same boat, correct? That it was part of the original plat. Nobody else had to put up a water share. Same situation, right?
Again, I'd need to look at the plat to confirm that. Before we go further, can I ask a question of the mayor? I feel like more this is a hearing versus a discussion. And if there is a possibility that my employment is at risk here, then I'd like to stop right now and ask for legal representation, because that's how it's feeling to me. So I need to know if the board is intending to take any kind of action against me. And if so, I guess I'm going to ask that we pause this meeting until I can have legal representation present, because I went into this with the impression that we were going to have a discussion. And I certainly feel like I am under a hearing or a trial, as well as my staff, and that is not fair to them. This feels very hostile to the staff.
Is there a way to ask questions that aren't in the form of a cross-examination where we can just
I don't know.
have this discussion on this issue?
Could be.
Let me make a statement, and I want to diffuse it again. We're not talking about termination. We're talking about an ordinance that wasn't abided by. We're not in a trial. Madam Administrator, you're being asked questions. Mayor Pro Tem Browning,
They're not questions about this situation. He's asking questions that sound like a discovery and that I don't have the answers to without having plats and zoning maps in front of me. If you want to know, did I issue a water share or exempt a water share? I've already answered that. Yes, I did. And I based that on the fact that this plot already had a water share assigned to it, just like every other lot on Mountain View Drive. And so that's really our statement. And I'd like to read my statement into the too. And I may be done answering questions. I guess you guys may have to make a decision.
Well, let me just say, what we're doing here is trying to gather facts, because there are a lot of inconsistencies with what the town attorney has told us and what we've been told already here tonight in this meeting and what was stated in your memos. And I don't know how to gather facts when you have inconsistent statements from the town attorney, the town clerk, and the town administrator without asking questions.
Okay,
That's what we're trying to do.
let's try it again. I have to tell you, it feels very uncomfortable, and it feels like instead of just coming to me 3 months ago and saying, hey, Victoria, what happened with this one? You have never had one discussion with me about it. Instead, you went right to the attorney with this and started a big investigation, and it wasn't necessary. And it doesn't feel very trusting of staff that have been doing this and issuing water shares and water taps for decades. So that's fine. Go ahead. I'll try to explain inconsistencies, but we have nothing to hide.
Okay.
And upon getting the memo yesterday from you, 27 hours in advance of this meeting, and finding out that indeed you were looking at, Trustee Browning, that you did ask if this was a terminatable offense to our attorney, I certainly was concerned. I had not gone into this with that impression at all until I got your memos a little over 24 hours ago.
Okay, which was in response to your memo that I got on Monday, 2 hours before the Monday board meeting that lasted till near midnight. So yes, it was late, but because we didn't see your memos until Monday afternoon. So yes, that's
I
true.
didn't send those. I sent those on Friday to our attorney. He sent the packet. Dolores and I have not sent any of these packets.
Can we keep it on the subject of this? And
Okay.
I want to get into arguments.
I'm not sure.
So
I'm just saying, staff did not send the packets for any of these executive sessions. We gave our materials to the attorney who sent them. If he did not do that in a timely fashion, then you need to address that with him.
And I sent the memos at 3:30 on Monday, and this meeting is Wednesday. And the reason it was sent on that time is was asking to see if there's anything else that needed to be added to the packet before sending to the board. So there's not multiple items being sent to the board, which I've been told in the past the board does not want. And the mayor said so long as it was sent on Monday, that it was acceptable.
That's beside the point, but that's why you didn't get my memo until yesterday, because I didn't get yours till Monday. I'm not saying that's your fault. I'm just saying
Lowell has his
that's what
hand
happened.
raised. Sir, Mayor Angelo, Trustee Lowell has his hand raised.
No, I'm sorry.
Mayor Pro Tem Browning has the floor.
So,
I'm sorry.
Mayor Pro Tem Browning still has the floor.
Where I was headed with the questions, and I'll just try to get to the end of it, about Turner and Reed and Mountain View subdivision and Kelling subdivision, is if the existence of water shares in the town's inventory of shares for properties that had been in the town limit since basically since day one, since the 1800s, if that excuses putting up a water share, even after Ordinance 1055, how would Ordinance 1055 have any effect whatsoever anywhere? That's my question. What's the effect of it?
You're just reiterating any new connections, meaning to me, any new subdivisions or annexations would be required. And that was already in the code.
Right, exactly. It was already in the code, so that we didn't need Ordinance 1055 to require water shares for a subdivision or an annexation. It was already there. Is it your understanding the purpose of Ordinance 1055 was specifically to deal with lots like 812 Mountain View and others that had been around for many years that there were shares for, but we were running short of shares? Wasn't it the purpose of Ordinance 1055 to deal with lots just like this one?
I don't know I don't know if that's the case or not, because I believe that when I was absent from a meeting, that the town engineer kind of scared the board into thinking we were low on water shares. And I came back and showed with the city of Longmont that we have plenty of water. And it was not as big of an issue as what people thought when 1055 was adopted.
Okay, well, on January 22nd, 2019, you were at the meeting, and the minutes of that meeting say this. Town Administrator Simonson stated that there are 2 lots in town that feel that they were assigned a water share years ago. There could be more to come. There could be more to come in to say that they are owed a share and we don't have any to give. So in fact, you told the board that we didn't have any shares to give, right?
Shares, yes, we have volume, but not shares.
That we didn't have any shares to give. When the 2 lots you were talking about, when you told the board that people might come in and ask not to have put up a water share, what 2 lots were you talking about?
I don't recall if it was Trustee Waz and Trustee Angelo's lots, or if it was other lots.
You don't think it was 812 Mountain View because you've been talking about that lot with Mr. Wickham for years?
I didn't know, because there were 3 lots on Outlook at that time that weren't built out.
And in that respect, when Town Clerk Vasquez responded to my emails asking about a water share on for 812 Mountain View, she said was, these older last buildable lots were what helped trigger the board's decision to change the code, if memory serves me correct. So wasn't it true that 812 Mountain View was one of these last buildable lots that triggered to Ordinance 1055?
It may have, at the time this was happening, no one foresee this occurring. I can't tell you the number of topics and conversations that go through your head as you deal with issues. I don't recall. But if that is the case, that was in my mind at the time, then so be it. And it did pass. And I did tell Mr. Wickham, you must turn over a share. I did tell him that. I was standing out in the hallway and he became very frustrated. I would use frustrated and livid as the expressions. And I'm happy to have you talk with him directly. He will tell you, Victoria told me I had to. And I became very upset.
Well, I don't question that. But where I'm leading to is with all this is, if Ordinance 1055 didn't require Mr. Wickham to put up a water share, and it doesn't require, for example, the 3 lots that are left in the Turner and Reed subdivision to put up a share, and I would suspect that Trustee Waz's lot is also in the old part of town. What was the purpose of 1055? Where do you think now today, that as it stands, Ordinance 1055 would apply? In what situation, other than subdivisions and annexations, which were already in the code, what's the purpose of Ordinance 1055 if it doesn't apply to lots like 812 Mountain View?
Well, now that we've recently had even more information, I don't think it's going to apply anywhere.
Okay. Yes, I understand that the situation has changed dramatically from what it was in March and April and May when you were addressing Mr. Wickham's thing. At that time, the town had received a letter from the town of from the city of Longmont. We were down to 0.2 shares instead of the 2.2 that the board was told we had left in 2019 when we passed Ordinance 1055. So yes, it's easy now to look back and say, oh, if we'd known we had 21 extra shares, not a problem. But at the time you say Attorney Dittman and Ms. Vasquez made the decision to waive the water share, the town had a letter in its file saying we were down to 0.2 water shares, didn't it? At that time.
Potentially, yes. I'm sure you've done your homework. That must be correct.
Town Clerk Vasquez, do you have any input?
This was a good way of explaining it, the way Ken Hewson and we all discussed. So let's say we're talking about all the old platted lots in town. Let's take Sandstone Park. If the town wanted to go build a maintenance shop there, sir, they could do that. They don't need a water share. That's an old platted lot. If we subdivide that and have 3 more lots, those 3 extra lots need to dedicate a share. All the old lots were covered with shares at the time.
Yes, but wasn't the specific purpose of ordinance 1055 to make the old vacant lots put up a share because we didn't have enough shares to cover them at the time? We thought we were down to 2.2 and then 0.2. Wasn't that the reason ordinance 1055 was passed?
I don't know, sir. You passed it.
Passed it, yeah.
Okay. If you want my, yeah, I think I do know. And I think the minutes of all 3 of those board meetings are clear that the town engineer came to us, the town administrator came to us, the town attorney came to us and said, you don't have enough shares left. We've got vacant lots out there that people think they don't have to put up shares for, some of these old vacant lots. You need to pass this initially, even as an emergency measure. And we did, not as an emergency measure, but because we were 1 vote short. But
And this is what I'm meaning by things are complex. That ordinance went in front of the board 3 different occasions, if I recall. Once as an emergency, it failed as an emergency, brought back again, failed again, and was brought back a 3rd time. So it really is very, very complicated. And when you ask me, did I say this on this date? And did I think this on this date? I honestly, I don't know. I know what ordinance 1055 says. I am not denying the fact that the intent was for Mr. Wickham and everybody else who moved forward to dedicate a share. I did tell Mr. Wickham to dedicate a share. I was then under his duress and with him once again saying, Victoria, I already have a water share. This doesn't pertain to me. And following up with the attorney, talking with the mayor at the time, talking with the staff who have issued all the other water shares in recent history, I made the decision, and I will take responsibility for that. I made the decision that in his particular case, and because I'm constantly and repeatedly being told, you must be business friendly, you must keep our word. That's the most important thing, keeping the word of the town. I made that decision, and I made it in the middle of COVID and I made it honestly under duress. Mr. Wickham came to me several times and said, have you made a decision? Have you made a decision after that? And I kept saying, no, I have not had time. I'm trying to get other things done. How about if I get back with you in a couple of weeks? And then finally a decision had to be made. So you don't have to, I admit it, I did it, okay? So, the cards will fall where they may.
Okay, well, here's a more general question. At the time all this came up, why didn't anybody bring this to the board's attention?
Because I felt like the previous board had already addressed it.
The previous board had passed ordinance 1055 requiring a water share for all new connections or taps, hadn't it? So I will agree with you that the previous board had addressed it, and it said all new connections, all new taps have to have a share. So
I'm not denying that. I'm not denying that.
In March, April, May 1st, when this was made, why didn't you inform the current board that this?
Because the current board was having emergency meetings about everything and their dog. It was not the timing for that. And Mr. Wickham and I concurred, and everyone else who was involved concurred, that his lot already had a water share. So 1055 did not pertain to him.
Okay.
That was our consensus, and we finally agreed we were all comfortable with that. Had any of us not been, I would have brought it to the board. And as I said in my memo to you, that I have learned a lesson from this. And if there is ever any doubt or question, I'm going to bring it to the board. Actually, I have one coming to you for September 8th regarding another issue at 427 Park. Okay. I'm supposed to follow the code, but your request is for me not to. And so I will bring that to you.
Okay. So Speaking of following the code, do you find it complex or unclear at all that the code says a water share requirement may be waived in the sole discretion of the Board of Trustees?
No, I understand that.
So something that the code says is within the sole discretion of the Board of Trustees, you made a decision about.
Well,
Yeah, I think it's fascinating.
I don't know that that code was in place at the time and if it was pertinent.
Yes, it was. It says in this, it hasn't been changed since March of 2019. It says the decision to waive a water share requirement is in the sole discretion.
If he had a water share before that, he had a water share before 2019. He had a water share back in 2003. So I did not see that pertained in this case.
And the board changed the rules. It changed the code in 2019. And as part of that code, it said only the Board of Trustees in its sole discretion can waive the water share requirement. So did you ever think about that part of the code when you're making these decisions?
You know, I think we discussed this so well before 10:55, and it was decided he had a share. I'm sorry.
After 10:55, something that the code says is in the sole discretion of the Board of Trustees. Why did you make the decision?
A prior board had told him he had a share, sir.
The prior board had never made a decision about Mr. Wickham's lot. The prior board passed ordinance 1055 to require him to put it.
I don't want to be argumentative.
Yeah, we don't want to argue. We're saying we did it. We did.
I understand.
We understand what happened.
Why didn't you bring it to the board?
Because it was COVID time. It was crazy. I don't think you have a good understanding of what the day-to-day operations within town hall are like during that time.
Do you have a good understanding?
I did feel pressured. I felt pressured that we had put this guy off and off and off for over 2 years. And he was waiting for something in writing. He was ready to build. And so we made a decision, and I'm taking responsibility for that.
Did you ever consider telling him, I'm sorry, I have to take this to the board?
That did not cross my mind. Because I felt he already had a water share, and this did not pertain to him.
So nobody ever brought up the possibility of taking this to the board?
Nope, never in the time I've been seated.
Okay. Those are all my questions for these people. I will state for the record before I yield to the other trustees that at some point, maybe not tonight because this is going to take a while anyway. I think that we need to have an executive session on this matter to be able to discuss in considerable detail some privileged communications back and forth from the town trustee to me and the board. Because I will just, without getting into the content of those, I will state for the record and for the public's information that what's been relayed here tonight about how this decision was made is in many respects and in some material respects contrary to what the town attorney my understanding of what the town attorney has his role in this. There are some serious conflicts and inconsistencies here, and I'll just state for the record that I think at some point we may need to have an executive session for the board in a privileged context to have a heart-to-heart talk and ask questions of the town attorney about his role in this respect. So
I'd be happy to answer.
I will yield the floor at this point.
Attorney Dittman.
Mayor Angelo, because because Administrator Simonson has asked to be conducted in public, I'm happy to answer any questions that I can. And if I think we were delving too far into privileged information, I can simply refuse to answer.
Trustee Lowell, you had a question?
Thank you, Mayor Angelo. My only question was, given that this meeting is for the purpose for discussion of personnel issues concerning Town Administrator Victoria Simonson. I'm a little unclear about what we hope the outcome of this meeting is going to be. If I had that, I might be better able to address the board.
Attorney Dittman.
Trustee Law, I'll try to answer your question the best I can, kind of given the constraints of the open meetings law. So I think the purpose for this, what was previously an executive session, was a fact-finding discussion as to what happened, and if the board determined whatever happened necessitated some sort of action, whether it be a reprimand or discipline or termination, if that was the board's ultimate conclusion, would take place in the public portion of the meeting, which is the next discussion item that's scheduled. So that's the way it was originally set up. So this portion of the meeting is for a fact-finding kind of experience. That was the intention of the board. And the next part would be whatever action is to be taken. And we can talk about what actions could be taken if the board decides it even wants to take action. The board's prerogative could be not to take no action based on what this portion of the meeting is found.
Thank you. I guess with the mayor's permission, I'm prepared to make a statement on this.
You may, sir.
Wait, do we make statements now, or do we let other trustees ask questions?
Well, Trustee Law can make a statement.
All right. I've got a statement too at an appropriate time.
Okay. Go ahead, sir.
Well, all right, I'll make mine now. I have no questions for Town Administrator Simonson, nor Town Clerk Vasquez, or Attorney Dittman on this. Let me just say, first of all, I admire the tenacity and thoroughness of Mayor Pro Tem Browning on this issue. And I'm confident his opinions on this issue are not personal, but rather reflect his commitment to both proper process and the greater good of the town. It's also clear to me that there has been an unfortunate level of tension throughout this issue. I hope we can be more respectful and in some cases more responsive to each other. As I stated in the July 22nd Board of Trustee meeting held for the purpose of considering a permit revocation hearing for 812 Mountain View, I believe then and believe even more so today that the history of this subdivision vis-a-vis water shares is spotty and that there are no definitive town records on this issue. Nor was there any consistency in the information provided to Mr. Wickham by town staff. Town records of the past 27 years neither confirm nor disprove the issue of a required water share for this particular lot. Facts were stated to Mr. Wickham by various town staff in the years 2003 to 2018 that the water requirements for his lot were satisfied. When he applied for a permit this year, Town Administrator Simonson reported that she told Mr. Wickham a water share would be necessary because of new ordinance 1055. At which point he pushed back hard, livid, as Town Clerk Vasquez recalls, and in the opinion of Town Council would have had a viable claim against the town if his building permit was revoked over this issue. In my opinion, Town Administrator Simonson did her job at that point and consulted with Town Council and Town Clerk, and in the end used her judgment to approve the building permit. She now admits that such a contentious issue should have been properly brought before the full board. But I'm confident that even with a board inquiry into this, the result would still be the same. If we denied it, the town was going to find itself in court. There was no compelling evidence in town records that a water share for 812 Mountain View was either necessary or had been satisfied. Town Administrator Simonson's only fault in this is a fault of judgment and not bringing the issue before the board. She has said as much tonight and in her August 14th memo. Instead, she used her best judgment after consulting with staff and council and allowed the building permit to be issued without the dedication of a water share. We pay the town administrator and town staff to use their judgment and skills for the benefit of the town. As a board, we should ask for reasons for decisions and offer both assistance and constructive criticism. But I do not believe we should take any action against Town Administrator Simonson when all evidence points to the fact that we as a board would likely have made the very same decision that she did. I find no malfeasance on the part of Town Administrator Simonson that warrants any type of reprimand or action by this board. Thank you.
Thank you, sir. Would any other trustee wish to ask any questions or make a statement at this time?
I have a kind of a procedural question.
Go ahead, sir.
Attorney Dittman, a few minutes ago, made some sort of statement about asking questions of him regarding these matters, and I didn't hear him clearly as to whether he thinks that would be appropriate now regarding communications he had back and forth with the board, or whether that should await a separate session, an executive session.
I'm happy to answer any questions. And I said, if the questions feel like delve too closely into attorney-client privilege information, I'll just say they're proper for an executive session. But I don't think, kind of given the information that's already been disclosed, we're really going to fall too far into that territory.
Well, I'll tell you, I've got some questions based on what I heard here tonight, and they come directly from emails that were exchanged between you and me.
Yep. No, I mean, it's the board's prerogative to waive that privilege anyways. I mean, I think it's better just to go through this right now. And if we get too far into something.
Okay, and I think this does relate to the Administrator Simonson situation, because if one of the reasons that she has given us tonight and in her memo was, I made this decision based on town attorney's advice, that really changes things from what the initial situation seemed to be that Town Clerk Vasquez had taken the position that a water share was required, but was basically overruled by Town Administrator Simonson, and that's not what we're hearing tonight. So that's why we have fact-finding inquiries, to see if what we were initially told is in fact what happened. And what we've heard here is way different than the initial responses that were made. And a very key part of that is, what role did the town attorney play in this? Because there's a big difference in any town employee making a decision that the code puts with the board on their own, and making that decision on the advice of the town attorney. And so I think the attorney's suggestion is well put. And I would ask the board, and I don't know if we need to vote on this or try to reach a consensus or what. I'd like to ask some questions to Attorney Dittman about statements he made to me, and also to Trustee Caravas, who was in on those emails, and that had been shared with the board, about whether the board would wish to waive the attorney-client privilege to the extent of asking questions about those statements. I'd be in favor of doing that.
And let's poll the board. Trustee Lowell.
What was that?
Would you be in favor of waiving attorney-client privilege for asking council questions this evening?
Yes. Yes, I would.
And I think you can ask questions without waiving the privilege. I think it's if you want to introduce the documents, you have to waive the privilege.
Excuse me, Counselor?
You can ask questions of me concerning the situation. It's only if you want to introduce the documents into the record.
No. I would like to introduce the documents into the record, the emails that I'm going to question you about. I'm going to quote directly from them.
Trustee Lowell, with that understanding, are you still in agreement?
Yes.
Trustee Miller?
If, yeah, yeah.
Trustee Rogan?
I'm a little unclear about why we're doing this. We know what happened. Administrator Simonson has been very clear. Yes, she made this decision. She's taken responsibility. I don't know what more information we're going to get by questioning the town attorney about the details of this that really makes a difference when we're talking about the subject matter of this particular meeting. If we want to talk about the inner workings or lack thereof between the town attorney and staff and the board and all that, that's fine, but I don't think that is this meeting. I think we need to stick to the agenda for this meeting.
I'll consider that a no then. Trustee Waugh?
I agree with Trustee Rogan. I don't think it's necessary. I think, you know, I agree also with Trustee Lowell with his overview. in general. I think the town administrator has already said that she's done this wrong. I disagree with Trustee Lowell that all members of the board think that the town administrator did the right thing. I think Mayor Pro Tem Browning is more about enforcing 1055 than doing right by our citizens in this specific case, and trying to make a point out of that. She broke the code. She violated the code. She admitted it, but by way of the citizens, she did the right thing. So I don't think we need to keep hammering the issue of why it happened or how it happened. I understand Mayor Pro Tem's suggestion that if she took this advice from Attorney Dittman, that's a different issue than if she decided this unilaterally. But who cares, really? She broke the code. You know, I'd be disappointed. You know, I'd like to see if there's is there a billing event from legal counsel on March 5th? Because it had to be more than a 15-minute call. It had to be. So, you know, that's kind of where I am, but I don't think we need to open up every email. I'd like to get on to what are we going to do about it and how are we going to prevent it in the future.
Okay, Trustee Caravas.
One side of me says I would like to open it up, but due to the length of this meeting that we're going and with the other statements that were just made, I don't see that it's totally necessary to do it. So I'm kind of like Wendy, Trustee Miller, that's kind of iffy on it. Like I said, I would like to see it opened up, but as we've discussed everything and all the questions, the few questions I did have been answered by the other trustees, by statements made by staff and other members of the board. So I would just like to see us continue on and move on at this point.
Counselor, let me ask you a question. Go ahead, make your statement first, sir.
Oh, I was just going to try to answer some of the questions if the mayor would like me to, concerning a couple of the inconsistencies and specifically the billing event.
But let me get back to the issue I was going to bring up, because we discussed this earlier. We are still entitled, if we wish, to go into executive session and discuss this in a more full manner. Is that not correct?
If it's about Administrator Simonson, then she can request it be in public, which is what was noticed. So I mean, that's kind of the issue, is that we noticed an executive session to discuss personnel matters related to Victoria Simonson. And so if it's with regard to someone else or more generally about staff, then it would have to be a separate posted meeting. And if it's about Administrator Simonson, then she has the right to have it in public.
Even in regard to board action on the issue?
Board action is a separate item. So that's the next item on the agenda. And that's not posted as an executive session. If it's okay with Administrator Simonson, there can be an executive session without her to discuss whatever it may be.
Okay. All right, then we'll.
And I apologize for the difficulty here. It's a unique situation.
Yeah, it is.
I had to spend some time with CML this morning to understand the parameters of this. Given that it's not often that someone requests it be in public.
So go ahead with your with what you were going to state earlier.
Yeah, so there was a couple of questions raised about one, whether it was a billing event regarding this, and I went back and looked through March and April and May. This is search, and I didn't see anything. And I know that the town clerk and the town administrator say that we did have a discussion, and we could have well had a discussion at some point in time, but it wasn't lengthy enough, or I don't believe it was lengthy enough to trigger a billing event. Normally I'm pretty good about getting those things down. However, just so the trustees understand what was going on at the time, it was during the middle of COVID, and we were literally on the phone pretty much all the time. And we were literally drafting all sorts of regulations and ordinances and stuff that had never been done before, pretty much constantly. And so it could have come up during a conversation during one of those times, and it just never got entered as a separate event. That's possible. I do not recall the specifics of such a conversation, but just kind of given how that whole time period was a blur, I also can't deny that ever happened. I was a bit shocked when this issue came forward, but it's only because I didn't remember it happening at that time. I wish I did. I think, something I've learned from this is that, be a lot more careful about documenting these types of things. At the time, I guess it didn't seem like it was going to become a big issue. Obviously, that proved incorrect. But that's kind of, my piece of this. I mean, and I think a lot of, the investigation, or I guess you'd call it investigation, that was done. It was at the very beginning, it wasn't even clear what exactly, my initial emails to Dolores, which I think provided the board, it wasn't even clear what lot we were talking about, as I didn't even know what 812 versus the other lots I discussed with Deb Anthony much prior in 2018. And so it goes to the complicated nature of this. And I think that's just answering some of the questions that I've heard, but I'd be happy to answer any more. So I think at this point, pretty much all the information is kind of already out there. It's not like there's any confidential privilege information kind of left at this point.
Mayor Pro Tem Browning, do you have any questions?
I do have some questions for Attorney Dittman based on some statements that I'm looking at in his emails to me that just simply don't square with what we've been told tonight.
Yep.
For example, discussing a conversation with Town Clerk Vasquez in between the passage of Ordinance 1055 and the March 2020 meeting. I was very clear that all vacant lots must meet the new code standards. Another statement. My position on the requirement for a water share has not changed since the code update, and Dolores agrees it hasn't. I don't recall discussing the property in any significant detail since that time. I can say with certainty that I have not discussed it recently and was a bit shocked that the building permit has just now been requested and issued. That just doesn't square with what we've heard here tonight. And it's disturbing to see those inconsistencies. And that's one reason that I sent the memo yesterday. I realized that what we had been told, what I had been told and had been shared with the board by the town attorney, just didn't fit with what the other staff members were now telling us. And to me, it does make a difference if any town employee acts on attorney advice or doesn't. One of my original questions in this whole thing was, why didn't somebody consult with the attorney about this? And now we're being told that they did. So it's a huge difference. And I've got a statement, if now's the appropriate time, or I think Ms. Vasquez wants to say something.
Go ahead, Town Clerk Vasquez.
And Brandon may have had his hand up before me, sir.
Attorney Dittman.
Attorney Dittman's.
I think, my statements that were in the email to Trustee Byrne, I still agree with. I don't remember having a conversation, but also don't discount now that two people said that we did, that we may have. But there isn't a billing event. I don't think it was extensive, because if it was, it probably would have been a billing event in my records. But there certainly was never a written legal opinion on this, and kind of given what we know in retrospect, there probably should have been, or a detailed analysis of this issue, rather than, if there was an opinion given, it was probably an off the cuff one, considering it wasn't not a billing event ever created. And I think, when that email was in response to a conversation I had with Dolores on the 29th, I think, directly after this issue was raised to me, and there was in June. And in June, I was shocked that the building permit had just now been issued. I had assumed incorrectly now that when I talked to Deb Anthony back in 2018 about this issue, the building permit for 812 Mountain View was issued then. And so that's part of my own ignorance as to what lots are what in town. And so I think if anything is clear, that there should have been a legal opinion issued on this issue, kind of given the gravitas that it has now had. And I think that's something that I've learned, is that we need to be a lot more careful about these things. There should be, when non-COVID emergency situations, especially, there should be written opinions on these things, because there is no documentation. I've literally provided the only email I have on this, which was from Dolores, sent from Deb Anthony's email, and I never read it. And that's because, one, it was sent during COVID, and two, it was sent from Deb Anthony.
Trustee Vasquez.
I just wanted to say, I take my job very seriously. I love this town. I always try to do the right thing. We would never make a decision without going to the attorney. And I can certainly understand if he didn't remember this conversation, because I don't think I had seen my kids since March. It was nuts in this place. But, and I'm not throwing anybody under the bus, because we all tried to do the very best that we could with what we had at the time. And that was the best information we had. And I can certainly understand if he doesn't remember, because it just felt crazy here at that time. But I just, everybody does the best that they can in this building, and including the attorney. And that's all I have to say.
Thank you. Any additional statements from anybody? Trustee Rogan, go ahead.
Thank you, Mayor Angelo. And thank you, Trustee Lowell. I wholeheartedly agree with your statement. So I won't go into great detail, but I would like to say that we're all human and we all make mistakes. And the middle of March was a crazy time that nobody had ever dealt with. And I am not surprised that a mistake was made here and there. I don't think there was any nefarious intention. I think the staff was doing the best that they could, and I think the staff does the best that they can. I want to go on the record as saying, I think staff is terrific. I see how hard staff works. I interact with them. I'm nothing but impressed. And I think that mutual respect goes a very, very long way in keeping the best interest of this town at heart, which is why we are all here. We're all here for that reason.
Thank you. That was an excellent statement. Mayor Pro Tem Browning.
Yes, I have a statement, and I had a statement prepared, some of which, most of which I'm going to make and read into the record. But this hearing and the information that has come out shows why fact-finding investigations by the Board of Trustees, when, as everybody seems to agree, the Lyons Municipal Code was not complied with, why the board needs to determine the facts and what happened before making decisions. Some of us have been accused, at least impliedly, of prejudging this and looking at having an agenda to fire the town administrator. That was a false allegation, and it's just not correct. This is the first time we've really had a chance to discuss this as a board with the town administrator. I made an initial, but I wanted to see the emails and documents, the things we've been talking about tonight, before I met with her. I didn't get those. I didn't get them until I filed a CORA request, because a written and an oral request weren't complied with. So I had to file a CORA request to get the documents. And then I've gotten a lot more information tonight. So the statement I'm about to give, I'm going to alter it somewhat because of the new information I've learned from our questioning and the responses that we got tonight. And some of the things I'm going to have to say, although prepared in advance to discuss a decision that I believe until tonight had been made principally by the town administrator, some of these statements are going to apply based on what we've been told to a decision that the town attorney helped make. With that, here's my statement. Contrary to what some would have the board or the public believe, whether to issue a building permit for 812 Mountain View was not a complex topic. It was quite simple. It was governed by a single, simple, plainly worded sentence in the Lyons Municipal Code. Quote, all new connections or taps shall meet the water dedication requirements. Indeed, the town engineer's January 7th, 2019 cover memo to the Board of Trustees that kicked off the whole consideration of Ordinance 1055 said, the ordinance makes the share dedication requirement much more straightforward. The town engineer was right. Assessing water share requirements after Ordinance 1055 was adopted in March 2019 was much more straightforward than it was before that time, than it was when Mr. Wickham was discussing with Ms. Simonson and Ms. Anthony and the attorneys at the time of the 2017 letter. Things were complicated back then. They weren't after March 2019. During the board discussion of Ordinance 1055, the town attorney who drafted this language gave this succinct and very accurate description of how it applied to vacant lots in town limits. Now everyone has to dedicate a CBT share. That's about as straightforward as it gets. After the ordinance was passed, the town attorney explained to the town clerk that it would apply to all previously annexed and subdivided lots unless there was a development agreement showing the requirements had been satisfied. There's some disagreements about things, parts of this, but everyone agrees on one thing. The subdivision agreement says nothing about water shares, and no other document talking about water shares for Mountain View has ever been located. So this was really a simple analysis. It's two questions. Number one, after 1055, did the property require a new connection? Certainly it did. Did it require a new tap? Either one of those, either or. Certainly it did require a new tap, and it was paid for. As the town engineer said in his initial memo, that was a straightforward analysis, and that should have been the end of the analysis. But rather than apply the clear, simple language of the code that the Board of Trustees in 2019 specifically adopted to deal with properties just like 812 Mountain View, and in fact, including 812 Mountain View, based on the town administrator's representation that there were two lots seeking to build without shares, it made the analysis simple. It was totally unnecessary after March 2019 to get back into pre-2019 history when the board changed the law. The board changed the law, not because the board was trying to screw around property owners with old lots. They did it because the town staff, including the town administrator and the town attorney and the town engineer, and on the recommendation of the UEB, came to the town board and said, we've only got 2.2 shares left. We've got more vacant lots than that. We can't tell you how many, but we're going to run out of water shares. We've got these old vacant lots that if we don't change the law, we're going to be short of shares. And that means the ratepayers of Lyons, the citizens, were going to have to fork over money to go buy CBT shares that cost about $65,000 at that time. The argument that Mr. Wickham should have been treated like all other property owners in Mountain View is bogus. The other owners built prior to 2019. The board changed the code in 2019. Mr. Wickham applied for a building permit in 2020. He was not in the same position as the other owners. His lot was governed by a new code provision, one specifically meant to cover lots like his. If a speed limit on a stretch of road was 60 miles an hour for decades, and drivers routinely drove at 60 miles an hour, they would not have been ticketed. But if the branch of government that sets the speed limits changes the speed limit to 40 miles an hour in 2019 and posted a 40 miles per hour speed limit sign, a driver in 2020 driving 60 miles an hour could not complain that I should be treated like the other drivers for many years who drove 60 on this road. The law changed. Governments can change laws. They do it all the time. My full Social Security benefit age was 65 for most of the years I worked. Now it's 66 years and 2 months. The government changed the law because Social Security funds were running low. That's what our board did in March 2019 for vacant lots in town limits. We changed the law because we were told that water shares were running low. And we changed it by a 6-to-1 vote on staff and UEB recommendations. Even though one owner of a vacant lot, namely Nicholas Angelo, private citizen at the time, complained repeatedly at public meetings that the change was unfair and amounted to the town going back on its word. The town did not go back on its word. To the contrary, the code says that any prior agreements satisfying water share requirements will be honored. We would honor an agreement to that effect. There just weren't any such agreements for Mountain View. And the board also left another opening for property owners in case, in addition to the prior agreements possibility. Any property owner could come to the Board of Trustees and ask for a waiver of a water share for a good cause shown. Good cause is wide open. It means the board can do whatever it thinks is right, but only the Board of Trustees in its sole discretion can do that. That could have been done for 812 Mountain View. Mr. Wickham could have asked for a waiver of a water share based on how Mountain View and Kelling owners had been treated, based on prior statements and promises that had been made to him by town officials in years past. He could have done that, but he didn't. Instead, in early March 2020, he met with the town staff and vigorously demanded that a water share be waived for his property. At that meeting, the town clerk, Ms. Vasquez, and apparently from what we heard tonight and in the memo, town administrator Simonson said no. They said they had been told by town attorney Dittman that all vacant annex subdivided lots required water shares. And they tried to follow that advice from what we've been told tonight. The permit was issued on that basis. They now say because the town attorney agreed to do that and gave them that advice. All three of those town staff members, including the attorney, had an obvious out to respond to the pressure being brought on them by Mr. Wickham. It was to take the matter to the Board of Trustees. The code is absolutely explicit in this regard. It says the Board of Trustees in its sole discretion may waive a water share requirement. Sole discretion means only the board can grant a waiver. Town staff, not even the town attorney, can do it. The other problem I have here is that after the building permit was issued and the share was waived, the board was never informed that that had occurred. This was the first time Ordinance 1055 had been applied since the board passed it in 2019. The board and the town administrator and the town attorney in particular had specifically discussed multiple times in public meetings that the ordinance would apply to vacant annex lots like 812 Mountain View. But when a request came in for one of the lots, the decision was made by all three of those apparently to tell the board nothing. Water shares are worth about $65,000 then. That's not chump change. There was also an important consideration of setting precedent as to how the new ordinance would apply to a number of lots in situations just like 812 Mountain View. There are three of them in the Turner and Reed subdivision alone. So it's not just the $65,000 share, it's setting a precedent. And if the precedent set here continued to be applied to those old lots, Ordinance 1055 would be a nullity. It wouldn't have any effect anywhere. 60 days after the permit was issued, the board got a report from the finance director that $28,000 roughly in tap fees had been received. So if it's important enough to report to the board on $28,000 in tap fees, why isn't it important enough to report about a $65,000 water share that could set a precedent for a lot of other lots at $65,000 a share? I had questions about these. I emailed the appropriate town staff members. It took 4 emails to get a response, 3 emails to get a response from the town clerk, 4 from the town administrator. Only at that point was it discovered that the water share had been waived. And when I discover something that indicates that a recent provision in the town code has not been followed by top town officials, my first thing is to contact the town attorney. And that's what I did. I did that actually after consulting with Trustee Caravas, because he's not only the UEB liaison, he was a member of the prior board and was well aware that, as was I, that the Ordinance 1055, the change we made, was supposed to apply to just this kind of lot. There are other problems here that I addressed in my memo. At a meeting on June the 29th, an agenda meeting, we talked about the issuance of a building permit, and the town administrator told me unequivocally, I do not know if a building permit has been issued. That just wasn't right. She had participated in a decision to make to issue a building permit, and it had been issued. She also told me at the same meeting that there were no documents or emails about 812 Mountain View. I did a core request. There were. those things bother me as well. When a trustee asks for information about a relevant issue, trustees should be responded to promptly and accurately. Conclusion. The issue before today is what should be done about staff conduct in waiving a water share contrary to the code, failing to seek board approval of that waiver, and even inform the board about it, and also misrepresenting things to a trustee who finally made inquiries. What I heard today changes the conclusion that I had reached in my statement. I believed that it was appropriate not to fire the town administrator. I've never believed that. The town has something like $70 million at stake in flood recovery, and the town administrator is the principal source of institutional knowledge as to many of the complicated flood recovery projects. Since the flood, the town has had 3 finance directors, 3 engineers, 2 sets of town attorneys, and 2 town clerks, but only 1 town administrator. Ms. Simonson's experience and expertise in the extremely complex world of flood recovery, requiring compliance with hundreds of detailed, constantly changing state and federal regulations, is invaluable. That's the principal reason I supported approving her new contract with a substantial raise last April, and I defended it in response to public criticism. I also believe she does a good job in day-to-day management of most town government functions. While it's tempting to take retaliatory or disciplinary action against someone who violates the code and doesn't tell the board about it and doesn't give a timely, truthful, or complete response to legitimate inquiries about a matter that belongs within the purview of this board, firing the town administrator is not the right thing to do here. The important consideration isn't how one may feel personally about a town employee or personal disagreements with that employee, but rather what's in the best interest of Lyons citizens as a whole. Putting them at risk for $70 million plus of flood recovery costs, plus disrupting normal town functions at a difficult time is not justified. I won't support that. The rest of my statement suggests the board consider issuing a reprimand to the town administrator for not following the code and for not timely informing the board about the action that was taken. However, given what I have heard today, I've changed my opinion on that. I will accept the statements of both the town clerk and the town administrator that the decision to waive the water share requirement in violation of the code was made after consulting with and at the direction of the town attorney. Those statements contradict flatly what the town attorney told me initially. Based on the fact that they acted on attorney's advice, that's the evidence that's in this record, I do not believe even a sanction measure such as a reprimand is appropriate. I do think that all have learned from this, and that from now on, when the code addresses something and puts it within the board's sole discretion, town management, including the town administrator, and I believe the town clerk, will bring that to the attention of the board. And if that's been accomplished, we've accomplished something with all this. I do have problems with something that is a clear, simple provision of the town code that, speaking for myself, I knew exactly what we were doing in Ordinance 1055. Mayor Angelo, then a citizen, told us it's not fair, don't do it. You're going to affect all these vacant lot owners who've had this for a long time. And that included him, and it included Mr. Wickham. Fair or not, the board decided to do it by a 6-to-1 vote because the town staff told us it was essential, it was an emergency, and we were going to put in jeopardy the taxpayers and ratepayers of Lyons if we didn't do it. That's why we did it. And to see that it was not followed, and that the reasoning for not following it would make it a total nullity. If it didn't apply to 1055, I mean to 812 Mountain View, it didn't apply to any of these other lots. But for the fortuitous circumstance that we have now discovered additional water shares, town ratepayers, if you applied that decision consistently, would be looking at coming up with something like potentially five more water shares at a cost of over $300,000 to keep making the same decision that was made on 812 Mountain View. I don't think that's the right result now, and I didn't think it was the right result when we passed Ordinance 1055. That's why we passed Ordinance 1055, specifically to avoid that result. That's pretty much the end of my statement. I appreciate the responses that have been received from town staff, the facts that have been brought forth in this inquiry. My tendency is to wait to make decisions until I gather the facts. Having gathered them, I believe that the town administrator and the town clerk ultimately made their decision to waive this water share, even though that violated the code, based on advice of the town attorney. And I do not think any sanctions or reprimands, and certainly not a firing or an order. That concludes my statement.
Does anybody else wish to speak in regard to the matter? Trustee Miller.
Yes, I would just like to add that the level of documentation and the level of communication that has historically gone on in this town has not been sufficient or reasonable even. I appreciate Town Clerk Vasquez for even documenting the phone call that took place on March the 5th, I believe. And at least having that document to go from. But I implore you, Town Administrator Simonson and Clerk Vasquez, to please document everything as moving forward on stuff like this. There's been so many incidences where we've had to go back and dig through years and years of records only to find that they've been misplaced or forgotten or not documented at all, or, you know, a whole array of situations. And I just feel like so much of this could be alleviated, so much wasted time and effort on behalf of town staff and the board of trustees and the town attorney to actually make that a priority. The communications of emails being returned promptly. I know we've discussed that in the past, 5 years that I've been on the board, and how important that is, just to send an email saying, got it, we'll get to it when I can, or whatever. It's communication and documentation in any situation is probably the key to success. So I am in agreement with Mayor Pro Tem that I don't believe that there should be any further action, but please take this piece that's happened and learn from it moving forward. And obviously it's been a rough 2020, but anyway, that's really all I have to say. I just urge you to document.
Excellent statement, Trustee Miller. Would anybody else wish to address the board at this time?
I'll make my statement real quick, if you don't mind, Mr. Mayor.
Go right ahead, sir.
Well, first of all, I'd like to thank everybody, especially staff, for being here this evening and Monday evening, and Victoria for the UEB meeting at 4 o'clock and meetings last week. So thanks for everything you're doing. You guys are doing a good job, doing great. As mentioned by everybody else, and you heard just the concerns of some of the information trails. Obviously, we're working on it. We've learned a lot since 2016. Since I came onto the board, with FEMA telling us, okay, one way was okay. Then, of course, we find out months and years later it's not. So we pass all the resolutions to memorialize what we've done in the past. Let's try to learn from that and kind of take that approach as we move forward with a lot of our in-house stuff or in-town things. And hopefully that can help what what Trustee Miller just basically said. Yes, I'm disappointed in when it was first brought to my attention, knowing a water share is not put up when we put forth all the effort to develop and build ordinance 1055, and that it wasn't followed. I was in quick agreement to find out why. Need to know that because we spent a lot of time and put a lot of effort and batted around ideas and amendments to build that ordinance. So I was very concerned why right out of the gate it wasn't followed. And I'm glad we had this meeting because as Pro Tem Browning indicated, more information has come out. There's inconsistencies with what we had online or in our packets and emails. And it definitely makes more sense from all my notes and my scribbling down. And I will remind everybody that at the very early stages when staff brought this to our attention, the UEB had made a recommendation that we need to do something because the information at that time was we're out of water, big problem. So the UEB is concerned, still is concerned. Not, as it was mentioned earlier, not being told about the waiver in our administrative reports where we do get information from all the different departments, public works with permits issued, permits pulled, work orders, stop orders. It would have been, this was kind of a big one. Probably should have been in a report that, it was waived and here's why. So we'll get better at that. Let's see, what else did I write down? Oh, and as we should have followed 1055 and let the owner at the time bring his request to the board to waive it, is when I first came on board in 2016, as we're right smack in the middle of flood recovery, and we were still even cleaning out homes from debris, we were finding areas of town that how homes were built over the property lines. And we very quickly in 2016, that board decided that, and I've said this to this current board before, that point forward, we need to follow the rules, regulations the best we can. Prior to the flood, there were some things that, handshakes, whatever, what happened, things weren't totally looked at, followed. Well, moving forward, we need to do that. And that's what we're doing. And that's why I agree with Trustee or Mayor Pro Tem Browning, bring this to our attention and looking at it. We said we're going to follow the rules. We're going to follow the rules. We're going to investigate them. Good. We worked it out, figured it out. Good for us. Prior to this meeting, there was a UEB meeting, and the new information that we discussed in our board meeting Monday, just so you all know preliminarily, I'll need to see how the UEB puts the minutes together, but it was briefly at the very end before I left to come to this meeting discussed what to do with about 10 ordinance 55, if anybody said anything about it. And the chair and some of the people were currently preliminarily leave it alone because we don't know what else is out there until we get full documentation on every lot. It's probably best to let it sit. So that's just your information moving forward as we go down the coming weeks and months and year. Again, Dolores, thank you for your time. I enjoy everything you do for me when I come and ask questions. So I look forward to seeing you more often as soon as we get through, as I think Trustee Miller said, this 2020. So hopefully we can get this year behind us quicker. Victoria, thank you for coming and dealing with us. And we'll probably still go to question stuff. That's what we do. That's what boards do. We need to, as we go through budget, we're going to question and ask, and we're going to hammer it out together. So hang in there. And at this point, as Mayor Pro Tem Browning said, and the other trustees have said, the information, bringing it all together to see, I don't think at this point anything else needs to be done. Victoria made her statement. Second thing is apologize, and let's move forward. Thank you.
Trustee Wong.
You're muted, Trustee Wah.
I'm sorry. So I've said this before already this evening. I'd like to, I personally believe that the town administrator and Clerk Vasquez made the right decision by way of the property owner. And I think the town administrator's decisions on a day-to-day basis typically are for the benefit of most residents in the town. So I think that she does a good job with that. I also believe that Mr. Wickham did not have malicious intent. He proactively solicited the town on multiple occasions and showed great concern about whether or not he was going to owe this share. He told me, he relayed a story to me about standing literally in a field with a farmer in Erie, and the farmer said, "I'll sell you a share for $22,000 in like 2006. He thought he had that in his pocket because he had been continuously told that he had this. So the previous town board passed 1055 on its third try. They were trying to make it an emergency ordinance because they believed it was emergency, and it was not. And we just had a meeting about this the other night. We had 21 shares then, and we have 21 shares now. What Mayor Pro Tem misses in his argument about 1055 is a small town adage, which you may not have in Austin, Texas, but in other parts of the world, it's called keeping your word and keeping commitments to your neighbors. I believe the performance issue from the town administrator is not this issue, but it's the previous lack of giving Mr. Wickham the letter that it was agreed to, I believe, in that meeting. And I believe, and I have personal experience, and I know others that have been committed a letter from the town administrator or other members of staff. That letter has been shown and drafted, but never executed or signed. So again, I think that we need to be concerned, because I think that these other properties that are covered by 1055 are going to have very similar verbal agreements. And I believe that Trustee Miller hit it perfectly. Since I joined the board, my entire term has resolved around some pretty significant issues, which are coming from the lack of diligence, the lack of documentation, the lack of consistently implementing things, and that's what's holding Lions back. And this continues to be an issue, and is the root of most of the things that have come before this board. Oh, I don't remember what happened. Oh, we don't have documentation about this specific item. And I'll tell you, Trustee Miller hit the nail on the head. We would have 10 less meetings this term if we had been documenting things and doing due diligence. And this has been continuously on the performance reviews of the town administrator and other members of staff. So it's something that has to happen. The other issue that I take a little bit at heart, and I applaud Town Administrator Simonson for admitting her error on this today, but reading her letter, and Mayor Pro Tem read this letter, I take some exception to some of the wording in this letter. The sentence that Mayor Pro Tem read about the situation at and I'm reading, quote, "The situation at 812 Mountain View is yet another example of not having clear documentation of what was agreed to by previous boards, yet trying to iron what individuals say they were told by town officials." They were told that by these town officials and town staff. It wasn't other people. If you go into that letter a little bit further, it says Mr. Wickham had been told by prior town officials over the years that he did not have to purchase the water share. The previous town administrator and the city of Longmont concur. So there's really nowhere in that letter from Town Administrator Simonson where she admits that or apologizes. It just says it's very complicated and I did the best I could based on the information that I had. So while I agree, this issue, she did the right thing. The town staff did the right thing. I think it's great. I applaud the mayor for putting 1055 back on the agenda, because I think it was developed under false pretenses and with erroneous information. And I applaud the town staff for doing it. I don't necessarily applaud the way they went about it, but I think you did right by the citizens of the town of Lyons by keeping the word of the town staff. And I encourage anybody in the public that's listening to this, document your conversations with staff, document your conversations with trustees, because what we're seeing and what we've seen for the last 10 years is if you think it's true, prove it, because we probably don't have the records. Thank you.
You're welcome. Would anybody else wish to comment? Well, that gives me an opportunity to comment. And since my name was mentioned a few times, I feel that I'm entitled. additionally to comment. I just want to add some additional language or understanding that was in 1055, and that's that no previous lot was grandfathered. That's a really important concept. I opposed 1055. I opposed it not only personally, which I stated initially, but I opposed it because it was a long-standing understanding of many people that had been in town for a long time. The agreement with Longmont is what solidified that concept also. The unfortunate reality of 1055 was that the concern was not based on facts. Additionally, we were very creative when it came to finding a way to accommodate water connections for affordable housing. Yet we couldn't be that creative when it came to previous agreements on 6 undeveloped lots in town. I was at those meetings. They were attempted by emergency ordinance. The question that I asked that couldn't be answered at the time is how many vacant lots, undeveloped lots are we talking about? Nobody had the answer. You cannot pass an emergency ordinance without a pertinent fact like that. Yes, there were more lots than shares that were represented that we had, but that was a misrepresentation. In addition, like I said, we were creative in regard to service connections for affordable housing. We have 500 acre feet in Button Rock. We have additional water shares. We could have been more creative to, and I don't want to overemphasize the term, keeping our word in that regard. So I was disappointed in 1055, but it passed. It became the law, and basically, you know, the people who owned undeveloped lots for 30 or 35 or 40 years, I was told by a very astute legal mind that for all intents and purposes, if you snooze, you lose. They didn't develop them in time. The water shares ran out, and that was the situation. But now we find ourselves in a position that Director Kaplan uncovered, that we might be able to address this issue at a later time. And I understand Trustee Karavis saying that the UEB would prefer to keep those shares, but honestly, you know, from my, not just take the personal aspect out of it. I've talked to Administrator Simonson about what I would like to do if the opportunity comes up. I think it's important for a municipality to keep its word. If we plan in the future to ever go before the public and ask them for a substantial bond to upgrade our water and sewer, we have to let them know that we have the integrity within our board to uphold our word and go forward and create confidence so that we can get some projects done that we need to get done. You know, so, I mean, to end my comment and what I told a couple of people online today and what I've told Administrator Simonson in meetings, you're not going anywhere. You have a job to complete. So I don't know if we have to give a direction to staff if we're in a consensus of not either admonishing or putting this in Administrator Simonson's record, that we can just accept her apology, ask her to communicate with the board comprehensively in the future, as Councilor Dittman stated, to have a precise documentation on any policy decisions that are carried out by the staff. I'm fine with letting things lay where they lie. What is the consensus of the board? Trustee Lowell?
I agree with your sentiments. Nothing should be forthcoming out of this meeting against the town staff.
Thank you. Mayor Pro Tem Browning?
I agree. Under the circumstances and the facts that have been developed today, I do not believe any kind of reprimand or admonishment is appropriate for town staff who acted on the advice of council.
Thank you, sir. Trustee Miller?
I'm also in agreement. I stated that in my last statement.
Thank you. Trustee Caravas?
I concur.
Trustee Waugh?
No action required.
Trustee Rogan?
Agree.
You have your decision, Madam Administrator, and thank you very much for the job that you do. Would you like to make a statement?
I would like to make a statement, and it was not pre-prepared because I didn't know what the outcome of this meeting was going to be. But I do want to let you know that I appreciate the opportunity to respond to your questions in an open and transparent venue. I think it gives confidence to both the staff and our residents that issues can be dealt with in a professional public forum. Perspectives can be heard and worked through. I do want to clarify one statement that I've heard several times, and that was that this was upon, I don't remember how it was worded, but upon the instruction of the attorney, because it was not. We did discuss it and there was advice, but he did not instruct us to move forward. That was my decision, just so you know that. I don't want Brandon to be thrown under the bus here. And secondly, that I really do hope that moving forward, since we are building a new team here, that instead of just going directly to a formal legal format, that if there's an issue with myself or my staff, that you as a board, and I think you're working on this as a task force, just come and talk to me first. I think we could have avoided a lot of this had there just been a discussion and maybe clarified some of this without all of the time and energy and just stress and anxiety it's caused not only myself, but the staff and you, I'm sure too. I also want to say that I hear loud and clear, and I know those of you who have been seated longer, that communication and documentation needs to improve. And I completely concur with that. And I also want to say though that my staff and I are overwhelmed. It feels like, you know, for the last 7 years, it's just constant learning curves and constant new people and constant new projects and constant contracts. And as you guys know, the numbers of resolutions and ordinances and meetings that have occurred over the past few years has like quadrupled from what they were prior to 2013. The reason I think we don't do a very good job at documentation and communication is because we are very time constrained. And I know we're going to have discussions about staffing. Dolores and I already work, 50 to 60 hours a week. And we're just going to have to make it a priority that at the end of every day, we make that documentation. It certainly is not a lot. We don't not respond to emails because we're trying to ignore you. Every day we have to make decisions about our time. And our time and our priorities are very splintered based on who is asking for what. And our first response is almost always going to be to a resident, because I've heard that in performance appraisals before. Secondly, to you guys, and then to staff and other folks. So it is not an excuse, and we will come up with a way. We will come up with a way to better document. I have no doubt about that. But I do want to apologize again for what happened. I do know that hindsight is 20/20, and that any concerns similar to this or issues that I feel conflicted about, I'm going to bring forward to the board, and you guys can weigh in on that. I don't want to shirk my duties or my responsibilities to make tough decisions. I've never shied from that. But if there is something at stake here that is a legal issue or something that could erode our integrity as a group, as a governing body, I'm going to bring that to you. So I do give you that commitment to doing that in the future. Thank you for letting us have this conversation tonight. And I just want to get back to our jobs and finish up our flood recovery and keep Lyons the absolute best place in this state to live. I mean, we all are very proud to live here. And I want to keep helping lead toward that goal. And if there comes a point where you want a different change in leadership, I'm a professional and I'm okay with that. Just tell me, we want to go a different direction, and let's come up with a transition plan. I'm really okay with that. But this has taken a toll on a lot of people. And I just want you to know that I have learned to be fairly tough skinned, although I'm crying like a baby right now. But it's because I'm passionate and I really do care, just like Dolores. We put a lot into our community, just as you do. And we're trying to do what's in the best interest of the whole. So thank you for the second opportunity here to prove myself to you, and I will do my absolute best. So thank you.
I think you're terrific, Madam Administrator. Thank you. Do we have a motion to adjourn?
So moved.
Do we have a second?
Second.
All in favor?
Aye.
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 Meeting is adjourned.
Good night.
Good night.
Good night.